And welcome back. We are glad you're still with us here on KBC Channel 1. Now let's flip pages and go into the eye on politics. Being a Monday, a lot happened over the past few days, and we just need to get into in-depth and understand what really happened, what it portends, and for you to understand really what we should look forward to. And in studio, I'm joined by Kenneth Amondi, who is an advocate of the High Court of the Republic of Kenya. And welcome to the program, Wakili.
Asante.
Karibu sana. And of course, joined by one gentleman, Dr. Rotich.
Thank you, sir.
He's disappeared. He'll tell us where he disappeared to, and he's back. Dr. welcome.
Good morning, Kenya.
Good morning.
I am so grateful that I'm back and in high spirit.
Absolutely.
And I want to thank God that I'm meeting my new friend, the advocate of the High Court.
Yes. Sure.
And welcome, my friend. And thank you, Oloo. We are together.
We are together. Thank you so much, gentlemen, for coming to the show. I think we should just start it where we should. And let me go straight to you, Wakili. We all know what happened. Perhaps for the benefit of the doubt, for those people who do not understand what really happened in court on Friday, the BBI, the cat is already out of the bag, and we have no any other option right now left as far as courts are concerned, though we hear that the AG is contemplating to go to the Supreme Court. Perhaps for you, from your own understanding, what do you take out of that court ruling?
Let me start by saying that I can at least give 4 propositions in respect of the BBI judgment on Friday. First, let me say that it was a monumental decision, that is from a jurisprudence aspect of things, in the sense that the Court of Appeal laid down the foundations in terms of how to go about handling referendums. I want us Kenyans to remember that the Kenyan judiciary has been in the forefront in terms of laying down formulas as we speak of how to conduct presidential elections. You remember the Maraga decision 2017, which was monumental. We have done the same thing again in respect to the holding of a referendum. Of course, there's also the fact that the decision buttressed the independence of our judiciary, so that to that extent, that would be a win-win situation to all Kenyans. Secondly, let me also say that that particular decision, in a sense, had a way, in a sense, it vindicated to some extent the president. I'm saying this looking at the decision of the High Court, because the High Court decision indicted the president insofar as, you know, the procedure that was followed in conducting the referendum, so that the general principle that came out was that, look, the president acted in good faith, but of course there was a problem insofar as the process is concerned. Thirdly, the next issue that comes about is in respect to the position of the Attorney General. I think we'll
discuss in a short while. Exactly. But let me just bring you in, Dr. Did you expect that ruling?
Considering, Oloo, the distance where we have come from and the challenges that we've encountered all along, anybody could guess that this thing was not heading for any good direction. Looking by it, the whole thing was supposed to be all-inclusive. The whole thing was supposed to be started down-up. It was not supposed to be top-down. So those are some of the things that you are not required to be a astute lawyer to know or a constitutional lawyer to know what was really happening. Even a layman could tell the direction of things the way they have happened now. So it never came as a surprise to me. But there are a lot of things that we have learned, Oloo, about the independence of our judiciary, and then the enlightenment that the Kenyans are at the moment, which of course it has really contributed a lot, because the Kenyans of the yesteryears, the last election, are not the Kenyans that we are experiencing today.
Yeah.
They are a very enlightened lot, and they were following every bit of what the judiciary was actually doing. They were also following every bit of what, how the whole process of the constitution amendment making. Kenyans have been just breached with the information that was happening. So the expectation that Kenyans had and the direction where the verdict has gone to, is something that many Kenyans are not surprised.
Yeah. Wakili, one thing that stood out was the public participation.
Yes.
And it has been contentious ever since the whole process started.
Yes.
But then now the judges came and said, you know what? There was no proper public participation. What do you understand by public participation? Because to Kenyans, the whole document went to the county assemblies, it went to parliament, and now went to the president, and finally, here we are today.
Let me start by saying that when you talk of public participation in respect to carrying out constitutional amendments that touch on fundamental aspects of the constitution that the judges refer to as the basic structure, then the aspect of participation of the public comes to the core. And that therefore brings us to the point of departure between the two strands in the referendum debate. There is that group whose argument was that, look, whatever it is, it shall be presented to the people in a referendum where they shall have the option of either voting for or against. But then there is also this other group, and that brings in the participatory theory aspect of it, that argued that even before you present this document to the public for purposes of voting, shouldn't it be that the proposal that we have ought to have incorporated the views of the wananchi? And when you talk of incorporation of the views of the wananchi, when you talk of public participation, then we go back to the phrase that was coined, the phrase of the constituent assembly, a phrase that was coined right from the days of, I think, the 2004 Njoya decision on the referendum. In which case we realize, and of course that is a law that the Court of Appeal was established by the High Court and reinforced by the Court of Appeal, that the nature of participation that ought to be inculcated involves, amongst others, you have civic education. There must be civic education. And then, the public must be engaged in terms of debating these particular proposals, where their issues will also be heard, will also be incorporated in the final document, which would thereafter be subjected to a referendum. So you find that it was not clearly demonstrated that that aspect was done insofar as the proposals in the BBI document were concerned. Just on a flip side, a replica of what public participation is and which the court meant can be captured from what happened pre-Bomas draft. And you understand that, there was that aspect of constituent assemblies in the ground. They were all inclusive entities that included people from, broad spectrum. You had the youth, you had the elderly, you had the disabled, all these fellas, and they would debate the document. They would then, for example, and I think, and that's what the court meant, the people would be asked, if you are talking of this body that was meant to oversight the judiciary, the office of the ombudsman, would you be, this is what the proposal intends. Would you be comfortable with the same? Would it amount to compromising the independence of the judiciary, so that by the time such a document is brought to the referendum, it can be properly said that yes.
Dr. What's your take on that?
I think, Oloo, what we must look at is in any civilized nation or people who are in the democracy, the constitutional changes should emanate from the felt needs of the common wananchi. It has to emanate from the people themselves. this is what we feel we should change in our constitution. This is what we feel we have to see in our country.
But there has to be an initiator.
The initiator, you see, what has actually killed the whole process is where the initiation actually, where it took up. It started from up down. And to me, I don't know, I don't really over-focus on where it started, but people must have, should have owned it. It should have owned the whole process. You saw, Mr. Oloo, the time when we were discussing here some time back, the ownership seems to have been taken over by the executives and those who matters in this country. It started from above, and it was moved by the same people. So that you can remember the time when the views were being given. Right Honorable Raila himself came up and said, no, the time is already over, we must move on. So receiving information from the public was curtailed at some position, whereby some people seem to have been chasing up to give their views instead of really people being given time to give their views. And of course, even those who were saying that it was time bad, they also had reasons that this thing has been dragging on for the last 2 years. We have had enough time to do that. And those who are actually not seeing the reason why more views were to be accommodated would give that we have given you more time. They were also reasoning on their part. But in this case, Oloo, when you talk about people's participation, as I have explained, it should have emanated from the felt needs of the ground man, the Wanjiku, on the ground, and it should have been driven by them. So the team that really carried out the collection of the views again, they were supposed to have been placed everywhere in this country, because the whole thing seems to have been hurried. Maybe starting from Kisii, it came to where, and of course within a period of 1 month, the whole Kenya was actually covered, save Nakuru, which of course the last minutes it was overtaken by the events. So in this case, we had we had the pastoralists who came later crying that they never gave their views. You had the churches who came later, they were complaining that they never gave their views, and so many other groups that were, who were complaining. You have heard Mudavadi say that this thing, if it was all inclusive, it was possible that it was going to have a breakthrough. That is, in his view again, the whole process was not inclusive. So in this case, Oloo, PPI died in its natural form. The way it started is the way it died. And if these people will take a back seat and come up again with the same views, I'm not seeing the problem of the same process.
That sounds so harsh on the initiators of the same.
No, I'm telling you the truth. Look at now what's happening. The HE is actually thinking about going back to the Supreme Court.
Right.
And in this case, unajua Oloo, hasira hazara. The back stop at him. All these processes was done in his presence. He's supposed to have guided the whole process as a legal advisor of the president or the government. So in this case, it is like anaona hii ni aibu, imefanyika na imefanyika tena. So I would wish that he sits back kidogo, let this process take a natural form, instead of confronting something that is already in the public domain, and they believe that the public knows that this thing is already dead.
Wakili, that sounds so harsh, the way he's putting it, that the BBI process started, and no sooner had it started than it died.
That is a possibility.
Let me put it like this, and that's why I really appreciate the position that was taken by the judges. The fact that we do not have a proper legal framework, as substantive law in terms of how to carry out, or rather how to hold referendums, would then, can be said to be one of the causes of the quagmire in which we find ourselves in. Because as a matter of fact, you cannot really say that all the proposals within the BBI document were anti-Wanjiku. In fact, 95% of the proposals are pro-Wanjiku. Where I have an issue with, what I would call those proposals that touch on the basic structure, and if I can basically mention two. On the independence of the judiciary, where you are saying that you want to bring the office of the ombudsman to oversight the judiciary, and then of course, secondly, on the purported proposals and direction to the IEBC in terms of how they ought to do their work. Of course, let us not forget that per se, the fact of increment in the number of constituencies would actually amount to more representation and further, in a way, decentralization even of funds, because more constituencies come with more funds. So those are pro-people initiative. But if you look at it from a fundamental aspect in terms of the basic structure, in terms of the fact that we need to protect our constitutional commissions, then there you find it's a problem. Yeah, so that I would say that the fact that we lacked a clear law in terms of how to carry out our referendums was the major cause of the problem. Yeah. And it's good that as we stand, the High Court, and as confirmed further by the Court of Appeal, has actually laid down a formula which must now be taken as the way forward.
In this case, who are the losers now?
From where I see it, I think the losers, it's three-way. Wananchi, the Wanjiku, in a way, because some of the proposals in the BBI, for example, the one on increment in disbursement to the counties, in as much as other people may say that, look, those are things that can still be done. I mean, if the executive are really keen on the same. But the mere fact that the same would be anchored on the constitution, as a matter of fact, immediately after the referendum, and now that is not a guarantee, then it means Wananchi are the losers. Of course, as a lawyer, and I want to repeat, I think the Attorney General of Kenya is in a very precarious position. I mean, from where he sits, because my understanding is that the moment he read the mind of the president, that the president was keen in ensuring that the BBI ought to form part and parcel of his legacy projects, then it behoved the Attorney General to ensure that he shepherded this process in a way that in the end of the day it had to reach a conclusion. And let me tell you, and in this I have in mind, I saw that the Attorney General intends to appeal,
to the Supreme Court,
and more so on the aspect of the IEBC. Although let me tell you, there is a crisis that is unfolding pursuant to that judgment, and precisely on the question of the IEBC. Because if, and of course that was a finding, and properly so from where I sit, that the constitution was not properly constituted in terms of quorum, so that it could not make such fundamental policy issues. And then you realize that as it stands, I am aware that the Commission has already initiated the process, for example, of procurement of the KM's kits, which was a core thing, if you can remember, in the nullified presidential election 2017. Now, don't you therefore see a scenario where, come the presidential election 2022, this is bound to be another key issue? I mean, in terms of if a presidential, if someone was to lodge a petition on the premises that the IEBC as constituted then...
Yes, they're not properly constituted. You can answer that. You can answer that briefly. But Dr. what...
I think, Oloo, I can categorically say we have lost greatly as a country. But the losses that are putting before us is the loss of funds. We spent a lot of money to fund a project that is dead. Number two, we have also lost our most precious time, which we would have used to do other things that would have made this country better than where we are today. Concentrating on something that has not bared any fruits. We have also lost as a country because of the greed. We were so greedy to be fast, greedy to own it, greedy to believe that others are less important than others. Had we agreed, I told you, Oloo, if you can remember our previous discussion, is that I wish Kenyans could listen, and we listen to every Kenyan. Are you getting what I'm saying? So that we would have drawn up a constitution that was all inclusive, a constitution that would have befitted every citizen of this country, a constitution that would have accepted without any contestation. I think you can remember what I said, that we were supposed to have gone to the referendum, not as people who are divided, but as people who are united in purpose and in objective to accomplish and to bring about the constitution that was acceptable across the board. But some never believed.
Are you saying that the money was, the funds were misused because the BBI has not reached its final conclusion? What if it passed?
Let me tell you, Oloo, before you do any project, you must plan for it. You must do a budget. And the plan should show, I mean, the plan itself should show even the results. It should show the outcome before you implement it. This was a national project. So in this case, I don't blame the project. I blame those who are managing the project. Because if the project is not managed and managed well, the outcome of that project will be very poor. It will be poor results. So in this case, the constitution, as my brother said, I mean the proposal for amendment, there were a number of views which were very, very, very wonderful. It would have changed actually the terrain of the welfare of our people. But look, we could not achieve because of greedy. I felt I should be the first to pronounce. I felt I should be the first to give my views. I felt I should be the only one who can give views and the rest no. That is not the way Kenyans. In fact, the courts of Kenyans have actually, they have proven us and that we were wrong in the process. We were wrong. Yes, the initiative, in fact, I don't look at Oloo, how it started. I'm not focusing on that. Whether it started from up, whether it started from down, but what I am really looking at is how we fail to have all Kenyans on board in the decision making.
Is it that the issue of inclusivity he's talking about, that Kenyans were not fully included in the whole process, Wakili?
I don't know if I can really call it inclusivity, but the main thing, like the court established, was the fact of just ensuring that whatever proposals they are, let them be subjected first to the people in the ground through the constituent assembly, so that they could also give their views for or against and probably even present counter proposals, so that the final document that is presented can then be said to be an all-inclusive process. That's what I got the court to be saying. And I know that's also what happened under the Bomas draft. So there was a precedent that could have been followed before we had this document presented to, the document finally presented. And you see, it doesn't matter as to whether, even if, because I know there's also the aspect of the political class, because remember that constitutional making essentially is a political process. So that now we had different political interest at play. There were some who felt that, this is something which was tailored towards, assisting some wing towards the election 2022 and such like things. And those are always bound to be there, because referendums in the end of the day are about yes or no. You win or you lose. So it has to be a contestation in the end of the day. It can't be uniform. If it's uniform, then it's not a referendum. But what is more fundamental is the process. There has to be a semblance of engagement. I think that is what I got the court to be saying. It must be demonstrated that in one way or another, the people, and especially the people in the ground, were so much involved and engaged in this thing, and especially when the final result, or rather some of the proposals, include what would be an assault on the basic structure. Yes.
And that issue of basic structure was deeply dealt on by all the judges. They dwelt on the basic structure. Dr. Briefly, before we go on a break, who are the losers in this particular situation, and the winners?
I think we have lost as a country. When you talk about winners and losers, I don't see winners. I don't see winners. Why I'm not seeing winners is that a constitution a constitutional amendment which was flawed has not succeeded. Yet we have spent a lot of money, we have spent a lot of time, we have spent a lot of energy, we have wasted a lot. So in this case, we have lost as a country a very precious thing to change the constitution that would have befitted Kenyans. So it was a lost opportunity, which we have lost as a country. We cannot please one another that there is a win-win. There is nothing called win. We have lost the money, we have lost the time, we even lost the energy.
Yeah.
So in this case, we have wasted our time. Much of what we were supposed to have achieved, spending 16 billion in in something that has not paid fruits. It is something that we must feel ashamed as a country.
Okay. Let's take a break, but when we come back, Wakili, the AG is contemplating to go to the Supreme Court to challenge.
Yes.
One, he's saying that the president, as a civil servant and as a citizen, on his own behalf, can initiate a process to amend the constitution. How true is that? And probably, what are the chances of the case sailing at the Supreme Court? Let's deal with that when we come back after this break. This is Iron Politics here on KBC Channel 1. And welcome back. You're still joined by Wakili Kenneth Amondi and of course Daktari Rotich here, who is a political governance expert and a political analyst as well. Gentlemen, before we went on a break, we just talked about the issue of the constitutionality now. Let's talk about the issue of the political implication. And before that, the Attorney General is contemplating to go to the Supreme Court to challenge some issues there. One, is he acting as an individual? Is he acting on behalf of his client, who is the president? And what are some of the chances of this case now sailing through at the Supreme Court?
Let me start by saying that part of the respondents, insofar as the petition was concerned, the initial petition was the Office of the Attorney General, which we know plays a critical role insofar as the whole of these processes are concerned. So that the Attorney General was in that proceeding, AG is in that proceeding as one of the parties. In respect of the grounds of appeal that the Attorney General has preferred, let me start by saying, and I'd actually said it earlier, that as an individual, I know the Attorney General finds himself in a very precarious position. And really, he ought to vindicate himself, because there are a lot of consequences going forward. Like I said, we have the question of the coming elections, the processes that the IEBC has so far undertaken, and the constitutionality of those processes going forward towards the election 2022, and even the potential of such issues arising during the an impending presidential election petition. So that on those grounds alone, even forgetting about the merits or otherwise of the appeal, I think those are some of the things that would motivate the Attorney General to appeal. From a personal perspective, and given my reading of that particular judgment, I really do not see much light in the end of the day insofar as the appeal is concerned. And my advice would be that the Attorney General would rather engage more energy in ensuring that we have a proper legal framework for carrying out a referendum, in also ensuring that in the processes that have been initiated so far by members of Parliament, because it is true that there are certain provisions, certain proposals within the BBI document that can very easily be shepherded through parliamentary initiative, and some may not even need a referendum.
Exactly.
So that within the context of Parliament, and given the majority that is currently enjoyed between the handshake parties affiliated to the handshake partners.
But then, Daktari, the question, even as the AG is now contemplating to go to the Supreme Court, he says that chances of the whole document sailing through at the Supreme Court is somehow narrow. The question is now, what is the political implication?
I think HE has been guiding the process of the constitutional amendment bill all this time long. He's been the chief advisor to in the process. And in this case, I think he should generally accept that he has lost this one. But going forward, he has to go to the drawing board, be involving in his mind setting, because we are heading for an election. And he's the center of everything. He has to advise the process so that we will have a credible election come 2022. So we have not lost yet, because we have a constitution in place. We have the 2010 constitution, which is quite perfect. Yes, we have not been able to improve, and we need to accept. The most important thing, Oloo, is to accept to accept first that we have lost, because going back to the Supreme Court to challenge the whole thing, it is a very frustrating kind of process, which of course he may not be sure of the verdict. And in this case, I would wish he relaxes, and then oversee other jurisdictions that will make this country move forward, and instead of putting himself in that precarious situation. But as far as politics is concerned,
because right now the legal aspect is now down.
It is settled. We know where it is now. Now then, when we talk about whether it was won by the several, the presidential or aspirants, I can say all of them actually lost an opportunity.
How?
Because in this case, in this country, Oloo, no single presidential candidate can win without a coalition. And you have heard of all these places. You've heard of Mount Kenya, that we can only change you when we have a share. We need to have a say in that government. We need to form that government. If you have to involve all these people in forming the government, I'm not only talking Mount Kenya, I'm talking about the Republic of Kenya. The stakeholders in the political process, they want to be the one being in the government. And they cannot be in the government if they are not part of those who, because if we had if PPI would have succeeded, we were going to have the position of the Prime Minister, we were going to have the President on the other side, we were going to have the Deputy President, we were going to have the two deputies of the Prime Minister, and of course the whole structure was accommodative.
And on the other hand, some of the positions were going to be abolished.
But especially for those, because they were saying that now with the ministers they were going to get, but it doesn't sound much, because when you talk about sharing positions, as some of these, I don't want to use that term, I mean at the national level, where we have the position of the Prime Minister, where we have the position of the two deputy prime ministers and the President. You see, these are the key positions in the government. These are the driving organs of the government itself. So if you have all your affiliation or coalitions being in the whole team, it would be seen as the all-inclusive in that sense. And of course, you don't forget that we were going to have an official opposition, whereby that office also is fully fledged in everything that it needs as a political, office that is putting the government in checks and balance. So in this case, as to whether they lost it or not, I can pronounce that all these guys lost.
Wakili, that sounds again so harsh to the political elite. All these guys have lost. So does it mean that 2022 we are going to go the same election with the same constitution as it is, where we have got the president, the deputy president, and the cabinet?
From where we are now, chances are likely, from a legal standpoint and given the remaining time, that we shall be heading to the next elections under the current dispensation, because the only other way, because I've seen some of those proposals in the newspaper that the parliamentarians intend to bring in through the parliamentary initiative. But let me say this. In as much as members of parliament have got that option of initiating a constitutional amendment process through parliament, but still, if you look at that provision of Article 255, it is expressed that there are certain entrenched provisions that if that parliamentary initiative intend to amend, then it shall behove the president, upon assenting to that bill that shall emanate from the House, to send it to the IBC for purposes of a referendum. And my thinking is that, my reading of the Constitution is that one of the clauses in the Constitution that would be affected is that which touches on the, altering of the executive structure of the government. Because you see, basically, if you were to do that, then you would be interfering with what I would say, and I think it's Justice Musinga who captured it well, will be, as we stand, we have a pure presidential system.
Yeah, it is.
So that if we are to introduce the office of the Prime Minister, Deputy, and ABCD, then we are going back to a parliamentary system of government. So that if you were to craft a change that will bring that sort of a change, then the same will have to go to the public through a referendum. So whichsoever way, if we were to have an alteration of the structure of the national government as it stands, that cannot happen before we head to a referendum. However, and I think then that is where the side of the coalition that may have the support of the president may have an edge. But now that is not law, that is now politics. Where the side of the coalition that may have the support of the president may have an edge. Remember that within the current constitutional dispensation and the executive powers that are enjoyed by the president, it is possible that he can craft certain positions, so long as it does not fundamentally alter the executive structure
of the executive.
So that given some of the rumors that we had in the press that the president actually intended to have some, the persons that he intended to support to have a government, some semblance of a government pre-2022.
Right.
Then in a way that can act as a plus for the persons who will then can then be said to be in the side of the president, other than the persons who will be moving as against the president, because then people will, your co-supporters will just have to trust that if you win, then you'll give us ABCD.
Dr. Most of the politicians are now going to start scrambling for those positions, because look at it this way: had BBI passed, the positions are going to be created for the expanded executive and what have you. But then now, it's all done. So what are we likely to see in terms of coalitions? Because we only have, as it is, from the way Wakil is saying, as it is, if at all nothing is done, then we are going to go to the next general election under the current dispensation of the Constitution. But then now the question is, so what next to the politicians?
I think looking by even the current scenario, Oloo, Ruto don't seem to have entertained coalitions as so far. But of course, what we are saying, as people who can analyze the politics in Kenya, you have to have a coalition for you to have a good win, or rather win. But in this case, there is a lot of confusion in the political realm as we are talking to, as it is now, because most of the politicians who are now eyeing to recover their seats back, they are eyeing the winning team. Who is a presidential candidate who is likely to win? Because even when you look at today's newspaper, Oloo, new poll, Ruto leads but can't win round 1. Because this paper seems to be campaigning for Ruto. In this case, if he is winning, yes, he is winning as per the current ratings. But for a politician who want to regain his seat, give away about what Kenyans will get. It's actually a personal survival. This is actually the time of political survival. I want to be in the next government. I want to see the president who is like, a presidential candidate who is likely to win. And I attach myself to that person. So that wave is there. And in the few months to the elections, Oloo, we are yet to see a mass movement, either going to, because now that we are seeing there are two main contenders. Yes, when Raila was in Nyanza, he shaded well that he will compete. Will compete with Ruto. That is what he opened up. That means, and he also said he has found a strategy to climb to the mountain. Climbing to the mountain, that means seeking the foots of Mount Kenya. So in this case, as much as he has not declared as a presidential candidate, there are all signs that he is for it. And Kenyans are watching. And they have also given their own direction that we are going to have two main contenders come 2022. Wajana mambo, hii mambo ya coalition, it will rally behind
but even as we say about that, in the history of this country, there is no politician has ever made it to the presidential seat without a coalition.
Of course, yes. And that's why I'm telling you, Oloo, as much as we have not seen in some quarters that they have not opened up, like the deputy president side, I think that is going by what is ahead of us. He has to impress the mode itself, because it is the only mode that can enable him to win. And in this case, we have two presidential contenders come 2022. That is Right Honorable Raila Odinga and the deputy president, His Excellency the deputy president. So in this case, people will now move in all directions. Some will move to Raila's followers, some will move to Ruto's, and as we move in 3 months' time, it will be, they will have shaped up and will show the direction where things go. But majority of the members of parliament, they are eyeing those presidential candidates who have a high possibility of winning. And they will rush there.
But we all know that politics is a game.
Dynamic. It's
dynamic. It's a game of changes and all that. Wakili, the question is, they are planning to go to parliament.
Yes.
And according to the paper here, they have got 52 clauses, BBI, 52 clauses that they are planning to table in Parliament. Let me just give you a rundown. Key proposals MPs want to pass through the House is increasing constituencies from 210 to 360. Protection of 26 constituencies that didn't meet the population criteria in 2012. We have nomination of presidential candidate and their running mates to parliament, and after a general election, we have got elected legislators in counties and national government be made members of cabinet. And perhaps it goes down there until the last one, increase of the allocation to counties to at least 35% of national revenue. What are the chances of these 52 BBI clauses passing in Parliament?
Like I said, we need to go back to Article 255. And then the question that we ought to ask ourselves is that amongst the proposals that are being fronted, which ones of these proposals would need, which of these proposals are such that insofar as we get the requisite numbers from Parliament, the President assents, then they become law? And which ones, are there some amongst these proposals which, notwithstanding the fact that they shall have been passed by Parliament, they still would need to go for a referendum? I think that would be the question. And you realize that, and I think some I can just flag off at the very first instance. For example, the ones on the IEBC, I think those ones, because they would go to, they may encroach on the role of the IEBC. So to that extent, even if parliamentarians agree and pass, but the next they'll need a further sanction through a referendum process. There is the question of having presidential candidates, becoming members of parliament. I also think that may fall within the same category, because remember, the system that we are approaching, we have now, like Justice Musinga put it clearly, is a pure presidential system. You decide you want to be president, and you forget about parliament. So either you are a president, that is the executive, or you are in parliament, which is the legislature. We cannot fundamentally alter that, because that will go to the root, to the basic structure, and it will have to go to the referendum. Otherwise, such provisions as CDF, in increasing the disbursements to the counties by to 35%, the question of bringing the War Development Fund, those ones can pass.
That one can pass.
Yes.
Even we are coming to a close to the show. The question is this a precursor to 2022? What we should expect, or is too early to preempt?
As you said, Oloo, that politics is quite dynamic, and but we have come for almost 4 years in politicking. And the direction of things may not change so much in the near future. Because if we were a country whereby we were respecting the law about politics, that politics we have to play politics when the right time comes, we would be thinking about those big changes. But as it is, we are a country that we have been politicking year ago. Even we started after the last election. So the way we are moving forward, there is nothing much that can change. What we are hoping that ahead there, if there will be any changes, it is about this coalition, knowing who has gone to the other side, who has gone to the other side. So in this case, that one now will determine how, the majority of those who will actually move from to the 8th side. Yeah. So in this case, 2022, as it is now, the shapes are getting created, or rather they are shaping up. And in 2 months, 3 months from now, we'll have a direction. And it is going to be a different election. Because you find Oloo, Deputy President and Right Honorable Raila were two friends who were together. These are guys who knows one another. So this actually a very powerful competition of wits. People who knows one another. They have worked together. So in this case, but either way, we expect come 2022.
Yeah. All right, gentlemen, allow us to stop at that particular point. The discussion is going to be quite interesting from now moving forward because, as I said, the political temperature is going to, it's going to be on a different temperature because we expect now politicians to take different grounds moving towards 2022. Thank you so much. We've been talking to Wakili, that is Kenneth Amondi, who is an advocate of the High Court, as well as Dr. Rotich, who is also a political commentator and a political analyst as well. Gentlemen, thank you so much for coming to the show.
Thank you so much, Oloo.
Thank you so much.
Thank you so much for your valid company. We're taking a break, but we're not yet done. We'll be back with more after this.